Thank you for attending this webinar. It's a pleasure to have you on board. What I would like to discuss with you today, and as said, please feel free to ask questions if you want. Put them into the chat. I think that's the easiest way to handle that. I would like to speak to you or discuss with you issues of IP when it comes to biotech startups, because what we believe is that beyond the regular role that is attributed to patents, patents and IP as a whole have a specific role in biotech startups, and we do this because we are very active in this field. And in the last year, for example, we have been able to support two biotech startups in their Series A financing rounds with a lot of success, and according to my opinion. And I think we would like to share part of our learning curve with you people. Now, let me just go to the first slide. When we speak about patents, or sometimes when you speak about patents, you very often hear mantras, and this discussion today is not focusing on mantras. This is just like a warning, because we don't want to use that. There's a citation by the former president of the German Patent Office, who doesn't invent will disappear. Well, I mean, that's sort of pretty much a Binsenweisheit, you would call that in German. I pretty much like Mark Twain, who is, I think, has put it pretty wisely by saying that if you don't have a patent office, if you don't have a patent system, your economy walks like a crab. That means sidewards and not back, not forward. And that is, I can fully subscribe that. Abraham Lincoln has also said another couple of interesting words. Then there's a nice quotation by the former commissioner of the US Patent Office about 120 years ago, who said, "Everything that can be invented has been invented." Well, that's probably not very prophetic. And that mirrors pretty much what my mother once asked me. She asked me, "Uli, is there still anything to invent out there?" And I said, "Yes, Mama, that's why I'm here. That's my profession. So maybe you look into what I do, and then you'll see that there's a lot to invent out there." And then there's, of course, Elon Musk, who says patents are for losers. Well, I don't subscribe that at all. So let's get rid of the mantra thing. In the startup microcosm, patents have a specific role. As you know, patents are granted for inventions, and they have an exclusivity period of 21 years. In return for an inventor to publish its invention. So in a way, it's like a reward for enriching the community with details regarding your invention. Now, in the startup microcosm, they have, I think, a more specific role, and that is to attract third-party capital, like, for example, in seed capital, in Series A to C, in IPO, or in exits. There's a saying, and I think that's oversimplifying things, but there might be a tiny bit of truth in it, that after 5 years after funding, the startup's only assets would be the patents. That's oversimplified in my view. There's also human capital, there's corporate culture, there's know-how and stuff like that. But what can be taken from that is that patents really contribute to the value of a startup. Well, this being said, I believe there's no other technical field or discipline in which patents play such a fundamental role right from the start. In particular, specifically in the startup microcosm. And when I speak about startup microcosm, I do not speak about taxi apps, web shops for love toys, or muesli delivery services. I actually mean biotech startups in this specific presentation today. What is important for a startup? You have to define your starting point, and you have to define your goal. And if that works out nicely, if that object is fulfilled, we as patent attorneys can start with an empty sheet of paper and sort of develop a patent strategy from scratch. So what is the starting point? Is it a new target? Is it a new molecule? Is it the repurposing of an existing molecule? Or is it, for example, a new technology, like, for example, genome editing, delivery, conjugation, sequencing, whatever? Then what's the goal? And well, the starting point is very often quite fixed. The goal is not always very fixed, and the goal can be flexible. You don't have to sort of focus on one specific goal. You can have different goals. One goal can be partnering or licensing out the molecule to big pharma. One might be licensing out the technology. One might be that you want to grow to become a long-time player by yourself. Or others other goals might be like an IPO or an exit or an asset deal. Then, of course, it's important to understand who is your competitor or who will be your competitors. That is very, very important. In particular, when it comes about drugs, is your future competitor rather a generic company or is it an innovative drug company? That's an important question to ask yourself and share with your patent attorney. And then, of course, once this is all established, you and your patent attorney can start up setting up a patent strategy. And there's one caveat, that is sometimes a situation arises where you have to take over an application that has, for example, already been filed by a university. And then, of course, your sheet of paper is no longer a white sheet of paper. So you have to sort of then work with what you get. And that's sometimes not the most easy task. Well, of course, like in regular things, the major goal of a startup's patent strategy should be to complement the product technology with a meaningful protection. If it goes around molecules, you want to be able to offer an attractive value proposition for investors or for big pharma. That means broadness of the scope, length of exclusivity, and also broadness of country scope. And then, of course, another goal is to maximize exclusivity duration, and that is in particular valid in pharma, where most money is earned in the last 3 to 5 years of the exclusivity period. Just consider pembrolizumab, which makes $29 million a year in turnover. Every single day of longer exclusivity is worth millions of euros or dollars. So that is something that we as patent attorneys have a particular focus on, to maximize exclusivity. And then when you speak about molecules, what we often do is we develop a staggered patent strategy. We start with a first generation that could be, for example, the molecule or the target, if the target is novel, which doesn't happen every now and then, doesn't happen that often anymore. Maybe then the second generation could be a formulation patent. The third generation could be a dosage patent, on and on it goes to extend the exclusivity. When we speak about technologies, it's important to understand the business model. Is it out-licensing the technology, or is it offering the technology as a service? Then, of course, it's important to understand which type of patent protects against which type of competition. That's, for example, when you speak about non-generic competition versus a generic competition. You would have to understand, together with your patent attorney, which type of patent requires long country lists, which requires short country lists. And then it's, of course, there's specialty knowledge, like, for example, what is a small entity, what is a large entity, what are patent extension schemes in the different jurisdictions, where, in which countries do BOLA provisions apply or research exemptions, and so on, and so on, and so on. And then, of course, what you have to avoid is, if you want to develop a staggered patent strategy, you do not want your first generation patent to anticipate every conceivable future embodiment. So in a way that second or higher generation applications are no longer possible. And that is a typical university problem, as I suggested earlier. Another point is that the typical biotech pharma startup does not sell products, at least in the early phases. As such, the freedom to operate issue is not, in my understanding or in my policy, it's not the prime concern. It becomes a concern in due diligence processes. And very often in due diligence processes, startups have to do their own FTO. We call it FTO homework. It's sometimes called vendor due diligence. But startups should not forget that in many cases, the risk of being sued lies primarily on the pharma partner. So if a pharma partner goes into a deal with a startup, they also have to do their own FTO in order to make sure that they do not run into uncalculable risks. And that is important to understand. You have to do your homework as a startup with regard to FTO, but it shouldn't be your prime concern. Then another question, and that's what we sometimes call the elephant in the room: how much is enough in terms of patent money? Very often we see that patent costs consume a significant share of startups' cash flow, and the biggest chunk of what goes into that budget is the number of countries you go into, and there's a general rule that's not always applicable, but it's a rule of thumb that for technology patents, the list of countries to go into can be shorter than for molecules. For example, with technology patents, the rule of thumb would be that you go into countries where the competitors have their seats, whereas with regard to molecules, you go into countries with the biggest markets. And then there's still the ever-pending question, is my country list long enough to represent an acceptable value proposition for investors? Then there's another issue. Once a startup has protected the basic technology or the basic molecule, does it need to protect every single incremental improvement? And then, of course, again, that is the question with regard to, does this improvement contribute to lifetime extension? If not, does it add value to the product if your product is already up and running? And still, because although sometimes companies ask themselves, do we do enough on the patent side? Do we spend enough? Do we allocate enough of our budget to patents? I believe that a careful and conservative filing strategy can also be a signal to investors that a startup uses its limited financial resources responsibly. So I think there are good arguments to not put all your resources into patents, and that might also be a signal to investors that this could be a good investment. Now, with regard to costs, that's a very simple scheme. A typical 30 months, the first 30 months of a typical biotech patent. For the first 12 months, that's the first time you put money into your hands for filing what we call the priority application. Some people call it also the provisional application. That is, the scope of these two terms is overlapping, but I don't want to waste too much time onto that. And then for the next 18 months, you have again to take money into your hands. And with these two budgets, you can sort of survive for about 30 months. And then the big money spending starts, because for each and every single country, you have to again take money into your hands. So the idea for a typical startup would be that you should have third-party capital at least shortly before the end of the 29 months term or the 30 months term to make meaningful decisions with a sufficient financial resources regarding the international filing strategy. And that is not always easy to accomplish, and we are fully aware of that. But in such way, with an overseeable budget, a startup can at least cover the first 30 months of the patent lifetime. What we as counselors often are confronted with is endless discussions as to which countries a client would want to go into with their respective patents. And the all decisive question then is, how much market do you get for your dollar or for your Bitcoin or whatever? What we have done is we have established an approach to address this issue with reproducible metrics, because very often what we encounter is that this question is very often addressed on pretty much on a gossip level, that people say, well, we want to go into this country for this and that reason, but very often these reasons are not reproducible. And what we developed in our firm is we try to provide reliable databases with reproducible metrics to provide reproducible decision basis for this question. We have in our database the average costs from national phase entry to grant in more than 30 countries, specifically for the biotech field. And when you plot these costs against the sizes of the respective healthcare markets, you end up with at least a workable score that gives you an idea about how much market do you get for your money in the respective countries.
Oli, ganz kurze Frage. Wir haben eine Frage von den Zuhörern, und we have a question from the listeners. Can you please explain the parameters for the definition of the country lists? But actually, you are doing that right now.
Yes.
So just so you're aware, people are very interested in how to select the countries.
Yes,
thank you.
Yes. And I know this is, and I believe there is value in this score. So I can go back. So what in order to get, well, you need two data sets. You need the average costs from national phase to grant in like 30 countries. We have that in our database because we do this for 20 years. And with regard to the healthcare markets, there's figures out there or numbers out there from the World Bank and from the International Monetary Fund. I need to say that the data set, and I'm explaining that later, is not specifically focusing on the markets for innovative medicines. That data set, at least I have never come across a data set for 30 countries that would give you metrics for that specific sub-market. So the market figures we work with is the healthcare market, and I show you how this has been done.
The question was about especially when to choose short and when to choose a long list for countries, or
yes.
What are the factors playing into this, basically?
Yes. So, well, first of all, like typically a technology patent would have a shorter country list than a molecule patent. That's maybe one rule of thumb. And then, of course, and we see this quite often when you look into the databases, very often the number of countries that you go into is pretty much dominated by the budget you have available. I've once written an article, I'd be happy to share that with you, where I did a study where I investigated lead candidate molecules of a selection of different biotech startups. And you see if that biotech startup has a pharma partner already, the country list is longer. And if it doesn't have a pharma partner yet, the country list is shorter. So with all the metrics kept aside, in the end, it's the budget that decides, which is maybe, I mean, that's reality. What I'm doing here is part of what I'm doing here is theory, but in the end, of course, the budget is the dominating factor. Okay, how do we come to the market size figures? When you take numbers from the World Bank or from the International Monetary Fund, you see the gross domestic potential, and I need to tell you this is logarithmic, and no surprise, the US is still the biggest, has still the biggest GDP, shortly followed by China and Europe. Now, there's other figures also from the International Monetary Fund, which give you an idea about how much money is spent of the GDP is spent into healthcare. And here again, not surprising, the US are overwhelming because we all know that the US have extraordinary healthcare costs. And if when you calculate this through, you get a figure for the healthcare market in all these different countries. And again, I need to warn you, this is a logarithmic scale. And again, no surprise, the the healthcare market in the US is by far the biggest in the world. Now, and that's for 2021, sorry, by the way, and that is not focusing on innovative medicines, it is covering the entire healthcare market. Now, this is the figures we have from our own database, which show you the cumulated costs for national phase until grant. You see that Argentina has seemingly a zero, and that is because in my career I have never seen a patent being granted in Argentina. So we do not have the full scope of cost for Argentina from entry of national phase entry to grant. So here we have just a zero. But for all other countries, we have reproducible figures. How much does it cost you from national phase entry to grant on average for a biotech patent? And this can give you an idea about the cost market size ratio. And as you see here, although quite a few people consider US to be a very important, expensive market, you see here in this figure, which is not logarithmic, that's linear, the US is obviously dirt cheap. And I have another figure just to make it a little bit more visible. That is normalized to EP and then again logarithmic. So when you take EP as one, you see that US is relatively cheaper. China is also quite cheap. But countries like, for example, Costa Rica are extraordinarily expensive, 100 times more expensive than Europe when you consider the cost market ratio. And on that basis, I believe in-house or we give counsel to our biotech startups, but I believe also on that basis, in-house counsel can have a database to give recommendations to their management regarding which countries do we want to go into, where do we get how much market for our money, and you could easily put a threshold somewhere here between 0 and 200 or at 400, just depending on your budget then. But I believe that such an approach helps to make these decisions reproducible. Yeah, I'm skipping this slide, sorry. I have a couple of case studies. This is a typical startup fighting strategy. It's one of our clients who have been making immunotoxins. That means not ADCs, not antibody drug conjugates, but antibodies to which a protein toxin is fused. So pretty related to actually the same market, but a different technology. What we did here, we started, so the orange bar is, that's actually the lifetime of the 21-year lifetime of the patent family. The orange bar is the 18 months window where the application is still not yet published. So what we did here, we started with a technology platform patent for the production technology. And then a couple of years later, about 2.5 years later, the company started to identify toxin classes for their specific molecule. And they ended up with 2 different toxin classes. And because the 2 toxin classes were so closely related to one another, what we did is we filed the third family, or the second toxin class family, we filed within the 18 months window to make sure that the first generation does not become prior art to the second patent family. Now,
Uli,
yes,
we have 2 very interesting questions.
Yes.
Maybe before we continue with the case study,
Sure.
One question is, the US family is much bigger than EP because of the numerous divisional filings. Is this considered in your model?
You mean this one? You mean this one here? In this model, no. This is per patent. This is per patent, and we did not, in this study, we did not consider divisionals, because divisionals are typically filed a couple of years after the national phase entry. So the time window for the prosecution of divisionals may be sort of distorted relative to the first generation patent. So we did not consider divisionals in this study. So the US cases which are considered in this patent, in this study, are the ones where the original, the parent national phase entry patent applications. Okay.
Then there was another question. First of all, they said excellent to these figures especially, and then the question is, has there been any data on cost to market ratio regarding opposition and infringement?
No. Well, probably yes. Probably yes out there, but not in this study here. So no.
Yeah, we could do this probably.
Yeah, right. But because this is focusing on startups typically don't file patent litigation cases, and they typically don't file oppositions. So that is, I mean, we have figures for oppositions, but not in this talk today. Okay.
Right. And then there was a question regarding your first case study.
Yes.
In this case study, the additional 5 years for pharma is not included. Question?
Right, not yet. Right, it's not yet. But typically, so you would get the SPC or the PTE regard. I think that this is what the questioner is alluding to, would sort of relate to this patent family here, where, because this would be the first composition of matter patent, which would then eventually result in a marketing authorization. So here you would have like the 5 years, the maximum 5 years extra lifetime. That would apply to this one. For the technology patent, and at least in my, if I were the applicant, I mean, I give counsel to that applicant, my counsel would be, of course, you could also ask for an SPC here if this specific toxin makes it into the approved drug, but I would recommend to demand for an SPC for this patent family here. Okay? Okay, so I think what's important here is to see that in order to make sure that these two patent families do not, or this does not become prior art against this one, that we're really keen on keeping the 18 months window here, staying within the 18 months window. So we had to really be pressuring. We had to pressure on our client to make sure, come on, we need the data, we need to file this before the first generation toxin patent is disclosed or is published. Now, the fourth generation is a humanized antibody that is conjugated to either of the two toxins. That is that's in the public domain. It's an anti-CD79B antibody. But here again, we didn't have to be too much concerned about our own prior art, because the humanized antibody the patentability of that is completely independent of whether these two patent families are disclosed or not. Another important feature is that has not yet happened. The client is now about to start clinical trials, and we have recommended to them, look, you have to do your clinical trial, you have to use a dosage, and you have to have a formulation. Make sure that you redact in all the documents that you submit with the regulatory authorities, that you redact any dosage information or any formulation information, and then file the patent once the marketing authorization is achieved, because then the dosage and the formulation will go into the public domain. So, and in this logic, the dosage patent, and in my personal weighing, the formulation patent, it has a lower impact to exclusivity than the dosage patent, but that is a different story. This would then be the one that would most contribute to the elongation of the exclusivity. Okay, and the client was quite successful. We have supported them, and in December 2024, they signed a 55 million Series A deal. This is another filing strategy of another.
We have another question.
Yes.
Sorry to interrupt. The average cost in validating were not only for a single market; they were general, like overall.
I need to look it up. I'm not quite sure.
Yeah.
I need to look it up.
Okay.
Yes. Yeah. Sorry.
Yeah. Thank you.
Yeah. Okay. This is another biotech startup client we have been working for, or we are still working for. And they had the privilege, and that doesn't happen very often, they had the privilege that they really came up with a new target. And that, as said, that doesn't happen very often. So what we could do is we could start with a target-based antibody patent. Well, quite a few of you might know that these target-based antibody patent claims are no longer patent eligible in the US, but we still did it. We informed the client, if we do this, it might happen that we have a dropout in the US, but I think it's still worth the money of filing this at that very early stage. Then the client, so the target was a 7 transmembrane domain receptor, and it had 3 extracellular loops, so 3 potential epitopes. And the client went on and investigated and found out there's only 1 epitope that has a physiological meaning. So within, again, the 18 months window, we filed a 2nd generation patent in which we claimed an antibody against that specific epitope. And again, we wanted to be in that 18 months window to avoid that this patent family becomes prior art against this patent family. Now, in this patent family, we had to disclose the antibody that we had that was actually able to bind against this epitope, and that was a mouse antibody. And we disclosed also the sequences of the mouse antibody. So, and that antibody was then later humanized. So again, we had to make sure that we stay within the 18 months window to make sure that this patent family does not become prior art against this patent family, because this is in the first place the value driver of the company, because this is the composition of matter that we want to protect. And again, here we would eventually demand SBC or PTE. And we went through quite a learning curve with regard to how do we have to optimize prosecution in order to make sure that we get the maximum in PTE, not PTA, PTE, but that's again a different story. The clinical trial is about to start, and what we did is, together with the clinical trial, because the indication, one specific indication was disclosed in the clinical trial documents, we filed a patent for a 2nd medical indication. And again, we will file a patent for the formulation and or the dosage by the latest, pretty much when the marketing authorization has been obtained. And again, we encourage the client to redact all information regarding the formulation and the dosage in the clinical trial plan. And Well, interestingly, in this specific case, we were able, the client was able to sign a Series A deal in September 2024 with about 65 million euros. And well, luck had it that this happened shortly before the composition of matter patent, that is this one, went into the national phases. So when you remember back, you want to make sure that within the 13 months window, you get your financing round closed. We were really lucky to accomplish that with regard to this specific patent. So this specific patent has now been nationalized on a very broad basis because the financial resources were there. So that was, I mean, in the end, it was sheer luck that we were able to sign that deal shortly before the 30 months period ended. Here you see that this is the 30 months period of that composition of matter patent, and we were able to sign that deal shortly before that. This is another case, maybe a little bit less strategic. That's an ADC company, and they started with a human library, antibody library technology, and then later on they developed a conjugation technology for an ADC. These are two completely different technologies, so we didn't have to observe or make sure that we stay within the 18 months window, but we did simply because it was the technical progress was, this case was filing ready at that time, and there was no reason to delay it. So just coincidentally, we stayed here within the 18 months window. Anything else is quite normal, only with the exception that there was shortly after the clinical trial was initiated, there was an exit in December 2020, and the client, the company was sold for 1.2 billion euros. That came with regard to the lead ADC molecule, which is this is their lead candidate. That came a little bit late, but still there was money enough because there were already Series A financing rounds earlier upfront to provide enough financial resources to really make a meaningful national phase entry for this lead candidate molecule. Well, this is another interesting case study. That's basically a company that has been using a technology, not a molecule. That company developed a directed evolution approach to mutagenize and screen enzymes, both for industrial and therapeutic purposes. For enzymes, their goal was to improve thermostability or pH stability, simply to make that enzyme better processable for like food applications and stuff like that. But they had a very ambitious plan with therapeutic enzymes. What they wanted to do is they wanted to develop a target-specific protease to digest an inflammatory cytokine. And that is really a goal, because you want to make your, I mean, if you administer to a patient a protease, I would be very scared about being administered a protease. So in order to be able to do that, you have to make sure that your protease is really target specific, and that was their goal. And eventually they failed. They didn't end up with an optimized enzyme that was target specific enough. So it was simply not, they could simply not administer to patients simply for safety concerns. When we took over representation of that company, the startup had realized that issue. They kept the industrial enzyme branch. They kept working because they were successful in that field. But they decided to switch over for the therapeutic arm. They switched over to therapeutic antibodies, and use the directed evolution approach to improve the affinity of a then existing blockbuster anti-cytokine antibody. That was Humira, by the way. We filed a patent for that firm. And shortly after that, the company, or the therapeutic arm of that company, was acquired by Big Pharma for 200 million euros. So this is not a linear strategy. They made a new decision. They realized their weaknesses. They made a new decision, and that decision eventually led to a financial success. Well, this is a spin-off we have been working for in Switzerland. They had a platform technology, namely a format for an antibody mimetic, and that platform technology that patent came with a relatively narrow country list, because that was a university patent already. So they took over the university patent, and because universities have limited resources, the country list was quite overseeable. That was not a big concern, because the patent did not concern composition of matter, not a molecule, but the technology platform. So that sort of pretty much fits into the scheme. Technology patents typically require a shorter country scope than molecule patents. The spin-off was very successful. They made an IPO for, I think, 130 million, and we supported them in that IPO, but they had a problem. The PhD advisor, the university professor of the inventors were former PhD students, and they founded the company, and they took over the IP from the university, but their former PhD advisor, he had kept the right to continue his work on the platform, and he continues publishing research results. And I remember I've been on a conference in San Diego where first that company presented their results, and later the professor presented its result, and there was a large overlap. And there was always the risk that what the professor publishes would be detrimental for the spin-off's patent applications, and that has been unsolved until today. But I think what's important here is for a spin-off or for a startup to really make sure when you take over IP from the university, to make sure that there's a clear cut between what professors still are able to do and what they should no longer do. I think that is really important. And there's maybe another, maybe this one. There's this one. There's another case study, and here again a spin-off from a university has licensed in its patent family from the university, and in this case it relates to a small molecule. Again, in this case it's probably more detrimental because the patent concerns a molecule, and again the university had only nationalized the patent in Europe and the US, and that is of course a pretty narrow value proposition for the startup with regard to potential investors. And then also in the patent application, there were a lot of analog molecules disclosed, and also a lot of potential indications were disclosed. So that university application really created what we call verbrannte Erde, or scorched ground, but just by simply making higher generation patents difficult to achieve for the startup. What we are discussing with the startup is to either further modify the molecule to be able to obtain new compound protection, or to develop advanced galenics or formulations or dosages. Dosages would be entirely new. Galenics, there's part of galenics is already disclosed in the application, but in any case, both alternatives come with a relatively long time constant, and that of course makes seed capital acquisition challenging. You have a lot to explain to your investors. Okay, we only have these two countries, but we have a plan to develop further IP, and then we have a broader country basis, and that is of course something where there's a lot to explain to potential investors. However, who is to blame? What could the university have done? Could they just on suspicion have put more money into the application in more countries without knowing that there would be an investor, or that there would be a spin-off? So I think there's nobody to blame. It's simply bad timing, and I do not see that there's anybody to blame in this specific case. Maybe we could skip that slide. I have one more slide that's interesting. That was a German biotech company which had developed a new protein expression system, and that was something that happened quite frequently in the first decade of this century. That people wanted to develop alternative expression systems, alternative to CHO or E. coli, for different reasons. And that expression system has advantages over both of them, over CHO and E. coli. It can properly fold proteins and disulfide bonds. It secretes the proteins into the medium. The yield is very high. Glycosylation is pretty similar to mammalian types. No serum is required, and the organism is not susceptible to mycoplasms and virus. So quite a few advantages. The company that is actually a spin-off from the university, and there was a university professor who had already 20 years of knowledge and expertise in that field. So they had a natural exclusivity for their technology because no one else in the world has ever been working with that. And they had a basic patent. But what they did then, advised by earlier counsel, not by us, they filed a lot of second generation patents for their technology. For example, they filed a patent on an oxytrophic mutant, they filed a patent on a heat-inducible promoter, and so on. And all these further developments would only work with the proprietary expression system, namely their own one. That would not apply for other expression systems. So the competitive edge they could achieve with that further generation patents, leave lifetime aside, was zero, because I mean nobody was working with the technology. So filing later generation patents which only apply to their exclusive technology, in my view, didn't add any further competitive edge, or at least only a tiny competitive edge. As said, leave lifetime optimization aside. But when we took over, well, when you typically take over a portfolio from another law firm, first thing you do is you want to get everything frictionless into your system, and you want to avoid any loss of rights. So, like for the first 3 months, it's only to get this into your docketing system, and then you can start considering, is the portfolio appropriate, or is there anything to be optimized? When we started that, the company had already an annual bill of 100,000 euros only in maintenance fees with us, because there were so many maintenance fees due. And actually, the investor was signaling that he would stop financing. So that company was facing bankruptcy with an open invoice of more than 100K with us, which made me quite nervous. So what we did at that time is we then started to wedge out the patent portfolio and reduce the cost burden, and that kept the company alive without losing its competitive edge, in my view. This is maybe something that is an important message, that because we are interested in long-term relationships, we are not interested in maximizing short-term revenue, because I mean, in the end, if the client is going bankrupt and can no longer pay his bills, that's not in our interest. So we preferred here to developing a long-term perspective with the client over maximizing our short-term revenue. Well, I'm almost finished. Maybe one very important thing, which really is something that keeps me busy, and that is when we discuss with universities. Well, I think quite a few university professors have swallowed, maybe not happily, but have swallowed the concept that if this is something that is patent worthy, you have first to file a patent application and then publish your invention. Now, that's not always sufficient. I'm just pointing you to the CRISPR-Cas9 case, where the group of Doudna and Charpentier, in the priority filing, they did not disclose the PEM site, which is something that plays a big role in CRISPR-Cas. The European examiner found that this was implicitly disclosed, so he waved that through. And in the first opposition instance, it was still accepted that even though that was not disclosed in the priority document, the technology was still sufficiently enabled. Well, the second instance made a U-turn and came to the conclusion that that E1 document, the first priority document, did not enablingly disclose the technology. The time rank shifted to P2, and I'm showing you in a figure, maybe that makes it a little bit more understandable. This is P1, the first priority document. This is the second priority document. This is the PCT, and I'll show you. Maybe that makes it a little bit. So in the priority document, the PEM site was not disclosed. For that reason, it's red here. It was disclosed in experiments in the second priority document, and then of course it was disclosed in the PCT. But the examiner said, well, this is an essential feature of the technology. It must be, it's important to really make the technology reproducible, and so the Board of Appeal came to the conclusion that the valid priority date is this one here. However, the same working group had in the meantime published an article, Jinek et al., which was the article that sort of got the whole CRISPR-Cas technology into running. So that's the most cited article in CRISPR-Cas. And in that article, they had disclosed the PEM site. So this article became prior art against this patent family. And you are asking yourself, these people put a lot of money into their patent strategy. It would have been an easy task to take the content of this article and file a further intermediate provisional here, sometime here, to make sure that the PEM site that they have priority for the PEM site before this article is published, but they didn't do it. And that is, I think, we still have a lot of educational work to do with university inventors to make sure, at least the file first then publish requirement at least applies over the entire priority year. Not only your job is not finished with your first filing. Whenever you publish, you have to make sure is there any additional content that could have a value for the patent application, and then file a cheap intermediate provisional. So we've been talking to university agencies who said, well, but that's expensive. And we say, no, it's not. We can do this. You can do it by yourself, but we can do this at a discount price. And in the minimum solution is just file your manuscript. So I believe there's still a high learning curve with universities. I skipped this slide because I do not think that this is utterly important. And this too, you know our firm, I hope, so I also skipped these slides just to tell you, and because I mean this is pretty much the reason why we do this presentation, that a lot of work we devote into biotech startups, and we have been quite successful regarding market authorization, regarding merger acquisition and due diligence. We have catalyzed deals in the range between 500K and 1.2 billion. And the two case studies I showed you, 55 million and 65 million Series A last year, were two out of the best valued biotech series in Europe last year. So I think we have quite a success story with this regard. And that's basically it. And Rolf, thank you for taking over. First of all, Rolf, I have to thank you for making this possible, for just helping us with the technology. And I think there is maybe some more time for questions, but yeah, thank you.
I have to say sorry that I was late, but thank you very much for this excellent presentation. Thank you so much. So are there questions? So if you want these cool slides with the cool statistics from us for your industry or for your case, please don't hesitate to contact Uli. He will be happy to help you.
Yes.
So these charts really had a lot of interest among the listeners. So it looked like it. So yeah, feel free to reach out to Uli. All right. So there will be a summary of the webinar on our website shortly, so you can always refer to our website and get a summary there if you want to revisit what has been said today. Yeah, thank you very much.
Thank you. I think I kept the time, right? Did I?
Or yes, you did. Excellent. Okay. Yeah, excellent.
Okay, good.
We would still have time for questions, but you answered everything probably. So, no, there are some questions. The problem with academic publications is that they publish earlier publications that are not novelty destroying, but raise an obvious objection regarding steps years before leading up to the patentable invention. So that was a comment.
Yeah, but I mean this is something we have no impact on. I mean, we try to educate university inventors in terms with regard to, it's not only first file and then publish, but you have to have an eye over the entire priority year. That is where we can educate with our limited resources, educate university inventors, but we can of course not educate them on their regular publishing strategies. That's impossible.
Then there was another comment. I doubt that you can deal with a professor that he may publish or not, except he works in security. But I think you can always also find, I mean, money talks, right? So if you can find a deal with the professors that actually develop further on this technology to maybe incentivize them financially to support the startup by not publishing so early, and then in return maybe have some other benefit. I don't know.
Yeah, I agree, and I mean it's well, in the ideal situation, the university professor has some equity with the startup, so that's a way to discipline him. And if you ask me personally, I mean, I understand that PhD students need to publish. I understand that, although my publication rate as a PhD student was pretty bad. But anyway, I mean that's not the deal here. However, I think as a university professor, you have a pretty good life. So I would think that in order to not put the success of your startup into risk, I think you should really be smart enough to sort of discipline yourself with your publication behavior. But anyway, I mean that's just my personal opinion.
All right. Well, thank you very much again, and to the listeners, feel free to stop by our website in a couple of days. You can find a summary there. And thank you very much.
Thank you. Have a good day.
Bye-bye.
Bye.